sind online.
Hello everyone, I would like to give a warm welcome to you to another session of Law After Lunch here in the law school, also in the name of Professor Christian Tietje, Azar Aliyev and Dr. Rath, who are so kindly joining us. I would like to welcome you to listen to the talk of Professor Jean Leclair from the University of Montreal. And I would like to give a special thanks to Marie-Claire Faubletz, the director at the Max Planck Institute, who introduced me to Jean Leclair a couple of weeks ago. And so I learned that he is here as a fellow during his sabbatical at the University of Montreal to work on issues that are very important and dear to us as well here in the law school, combining legal scholarship with research on indigenous issues. As the title of today's talk illustrates perfectly, the fate of indigenous legal orders under American, Canadian, South African constitutional law. Professor Jean Leclair holds a bachelor degree at the University of Montreal, also an LLM, and he was appointed in 1991 as professor of constitutional law and legal history. Founded a course on indigenous people and Canadian law, works on environmental management in the federal Canadian framework, constitutional foundations of Canadian biodualism. So what I find particularly intriguing is the combination of federalism and indigenous issues in the law, and that from a comparative and interdisciplinary perspective. I think that's just very, very appealing, very interesting, and therefore, without further ado, the floor is all yours. Thank you so much for coming.
Well, thank you very much, Professor Henschel, for having invited me. It's a pleasure to be here, and I'll leap into the subject right now because I don't want to speak more than 40 minutes so that we can have a talk afterwards. So, what I want to discuss today is the fate of indigenous legal orders under American, Canadian, and South African constitutional law. A very big topic for 40 minutes. So, whoops. Okay. So, some preliminary comments. First, about vocabulary. I will sometimes use Aboriginal or Indigenous. I use Aboriginal because that's the word used in Canadian constitutional law. For some reasons, the word Indigenous, which is most used, it was not used by the Constitution, the writers of the Constitution in 1982. I will speak also of indigenous legal orders or customary legal orders, because you'll notice that in South Africa, whether the communities resorting to customary law are indigenous is a matter of debate, as you must know for those of you interested in indigenous peoples. Not every African is indigenous, but I still will compare the two because indigenous legal orders and customary legal orders bear some similarities. The accent they put on actors instead of norms. The accent they put less on the application of norms, but on searching for the outcome that is best suited to the situation. The emphasis they put on social cohesion, on community rather than individuals, and on their modes of processing also, their processes of conflict resolution. So that's why I'll use indigenous or customary legal orders. I will also be basically talking about legal pluralism. Legal pluralism is a situation in which two or more legal systems or bodies of legal norms operate within the same social field. So they overlap one another very often. From the point of view of an individual, legal pluralism prevails whenever a person is subject and has access to more than one legal system. That's pretty basic, but I wanted us to start with on a common ground. And a legal system, as you will see from that definition, a legal system is not confined to state legal systems. A legal system is made up of a body of interrelated values, principles, norms, and of actors and processes. Think of religious orders, for instance, with their values, their norm, their actors, their processes. Same goes for indigenous legal orders, customary legal orders, or non-state legal orders, if you prefer. Now, legal pluralism challenges the statocentric perspective, which is the one you're facing every day as most of you students in the law faculty. That is the ideology of legal centralism. Law, that is defined by Griffiths as law is and should be the law of the state, uniform for all persons, exclusive of all other law, and administered by a single set of state institutions. That's statocentric understanding of law, which is the one we learn in law schools. Now, states can ignore non-state legal orders. They can informally tolerate them, accommodate them, they can repress them, they can suppress them, or they can recognize these non-legal orders. Now, when they recognize legal orders, and that's the situation in the US, in Canada, and in South Africa, they can go about it in two ways. Normative recognition, which means that that happens when state institutions treat substantive norms, rules, principles, or both, of customary law as valid norms of state law. And so the state institutions, the court, recognize the norms of the other legal systems, but not the actors, not the processes. Institutional recognition happens when state law treats acts of customary law institutions, such as dispute processing decisions of traditional authorities, as having valid effect in state law. So that's much more generous in a way, because it leaves the system operating as a whole, producing its own norms according to its own values, according to its own processes, but the government then only takes, for instance, the validity of a customary marriage at face value and recognizes it for different purposes in state law. But it doesn't define what is a customary marriage. It leaves it to the norms, the values, the principles, and the different institutions to determine what a valid customary marriage is. Now, what I intend to demonstrate is that all three jurisdictions, USA, South Africa, and Canada, have enshrined some protection for indigenous interests in their constitution. I write interest and not legal system because of Canada. Canada, as we will see, does not recognize legal systems. But all three have chosen different institutionalized strategies to do so. US constitutional law embraced limited institutional recognition, as we will see. South Africa's constitutional law embraced limited normative recognition, and Canada has chosen an altogether different path, constructing a legal doctrine of Aboriginal rights that makes no reference to either living customary laws or contemporary Aboriginal institutions. That's what we'll see. So we'll go through, and it goes without saying that context matters. See, constitutional recognition of Indigenous difference happened at very different times. The decisions I will be mentioning about the USA dates from the 1830s. Canada enshrined Aboriginal rights in 1982, and South Africa in its post-apartheid 1996 constitution. Colonialism happened in all those countries, but very different effect. The demographics are radically different also. And so the de facto existence of indigenous legal orders varies from one country to the other. The USA, recognition of indigenous legal orders in the USA. The US Constitution does not explicitly recognize any rights or jurisdiction to Indian tribes. It's the Supreme Court of the United States, three famous decisions at the beginning of the 1830s, that declared that subject to Congress's plenary power, Indian tribes are sovereign in the sense that they are recognized as political communities. They are defined by the court as dependent domestic nations. So the very institutions of Indian tribes are recognized, and therefore the norms they create and the actors they comprise. This means that Indian tribes possess the power to prescribe laws and ensure their implementation, And Indian tribes possess their own political institutions and their own courts. They have civil and criminal jurisdiction. It's important to remember that state and federal courts in the USA are never called upon to interpret Indian law. These are left to the Indian institutions, which have jurisdiction over their people and their territories. This power, recognized by the Supreme Court to Indian tribes, is said to be inherent in that it does not flow from a delegation of power by the American Congress, but rather from the sovereignty which Indians tribes Just a few words about population. There are 5 million native Indians in the United States, comprising 1.5% of the overall population. So from what we've seen, in the US, the government, and the court, under the pressure of courts, has adopted a policy of limited because the plenary power of Congress, limited institutional recognition. But the Indian tribes have full opportunity to develop their laws as they wish them to be. And if you go on Westlaw, you can have access to hundreds of thousands of decisions of tribal courts that are reported. And some of these courts are very sophisticated. I mean, the Cherokees have 3 levels of court: trial, court of appeal, Supreme Court. Sorry. Okay, South Africa. Law will be applied by state courts, which is not the case in the United States. This doesn't mean that customary law does not continue to be applied outside of state institution, which is also very much the case. In family matters, they rarely go to court. But if they go to court, the courts must apply customary law when that law is applicable, which means in matters of land, marriage, divorce, and other related aspects, subject to the Constitution and any legislation that specifically deals with customary law. So again, we see this plenary power, this capacity of the South African state to impose its will, to abrogate customary law if it wished to do so, but it doesn't. And post-apartheid, it became impossible to deny the existence of this multiplicity of customary laws applicable in South Africa. And when interpreting any legislation or customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. In the post-apartheid context, it was impossible to authorize, especially in the Constitution, objectionable behavior even under customary law, which can be very paternalistic and provides for a very unequal status for women in marriage, in inheritance, and in land laws. So, in South Africa's post-apartheid constitution relies on a conditional form of normative recognition. Now, that kind of recognition raises some challenges. For instance, it ignites a debate about the historical authenticity of customary past, which means that when you go to court, and you claim that customary law should apply because two indigenous African litigants are in question and the matter can be resolved under customary law, well, there can be a battle as to what's the historical authenticity of the custom that is claimed in front of the court. And so these kinds of debates can really rip apart even customary communities as to what is the true identity of the custom. The second problem, which is created by normative recognition around the world where it is used, is a gap between the living and the official customary law. What do I mean by this? Customary law is not something that is ossified. It breathes, it changes with time. But when you go to court, and the court settles on the interpretation given to a particular custom, then it some sort of freezes that custom as it defines it. This decision becomes a legal precedent, and the custom mentioned in it stops evolving. And so this distance is created between the living customary law of a community and the customary law as recognized by state institutions. And finally, the third problem raised by this kind of normative recognition is that it relieves a gap between tradition and modernity. What do I mean by this is that if you take, for instance, the Constitutional Court of South Africa, many fascinating decisions have to do with the court looking at traditional customary laws, identifying them, and then trying to modify them to make them fit the equality provision recognized under the Bill of Rights of South Africa. And then you have this gap between this traditional understanding of the customary world and the need to adapt it to more Western understanding of what is right. And you have this situation in many countries. Some countries like Zambia chose to mention in the Constitution that the equality provision does not apply to customary legal orders. It depends on what and how far the state is willing to go in the recognition of the autonomy of indigenous or customary legal orders. Now, what about Canada? Canada, I'll spend a little more time on it, and actually it's my country. Canada is made up of 10 provinces. Even the small one here is Prince Edward Island, 100,000 citizens, Ontario 11 million, and 3 territories. But Canada looks like this since 1999, but it looks like this today. But in 1867, when the Federation was created, all of Canada was these 4 provinces. BC was a British colony, but it was independent. And so, in order to create Canada's, what is Canada right now, a lot of treaties, land surrender treaties, the 11 treaties in the green here, had to be signed with Indigenous peoples so that Canada could run the railway across the country, appropriate the land for cultivation purposes and everything. But you'll notice that in present BC, a lot of Canada is devoid of any land surrender. These are peace and friendship treaties that I will mention. They don't comprise any land surrenders. So in these areas, you have claims to territory by Indigenous groups today. Of an unbelievably short history of Aboriginal peoples in Canada. Prior to the 19th century, Aboriginal peoples were subjects of law. I mean by this that they signed treaties, peace and friendship treaties, treaties of military alliance with the British, with the French, with the Spanish, all the countries you want. But in North America, it was mostly the French and the British. And so they were treated as equal. Never would the King of France think of imposing its own criminal law to Indigenous natives. And actually, if he wanted to, he would have been killed immediately. So they had to operate by treating Indigenous as nations. From the beginning of the 19th century, the 1960s, Aboriginal peoples became objects of law. That is, they ceased to be considered as having political autonomy. Why is that so? Of both Americas. If you want to read the book 1941 by Charles Mann, it's a fascinating story. These were germs carried over by the Westerners that were, had lived with their own animals, and all the animals had transferred their own germs to the humans. They built up the antibodies necessary to fight this. But when they arrived in North America, these antibodies did not exist, so people died from the flu, from smallpox by the millions. And so there was this demographic crash. That was one of the reasons. The second reason is early in the beginning of the 19th century, Indians ceased to be military and economic allies. New France was conquered. The whole thing was now British until the Americans became independent. But after the independence of the Americans and a war nobody knows about, the 1812 war between the United States and Great Britain, there has been no warfare on the North American continent, apart from the American Civil War, but that doesn't concern the indigenous peoples. The fur trade just collapsed. And so they became obstacles to colonization. And that's when the famous Indian Act in Canada was created. The Indian Act is a piece of legislation that aimed at settling these semi-nomadic and nomadic peoples in reserves, very small, you'll see further on, to settle them, Christianize them, and civilize them. The very first act in 1851 was an act to civilize the savages. And the land surrender treaties I mentioned were signed. These were no longer military treaties. These were land surrender treaties in exchange for small reserves and in exchange for a right to fish and hunt on what was called crown land, so the land, the dominion of the government. From the 60s onwards, Aboriginal peoples as subjects of law, decolonization, freedom movements all over the place, charismatic leaders, major inquiries in Canada about the fate of Aboriginal peoples. More recently, the Truth and Reconciliation Commission that concluded that the residential schools that were operating between 1835 and 1996, to which Indigenous children were forcibly sent to so that their culture could be eradicated. Well, in 2015, the Truth and Reconciliation Commission concluded that this was cultural genocide. There is now a commission on missing and assassinated Indigenous women and girls in Canada, another great black spot in Canadian history. So a lot has been changed. There was the signature of the United Nations Declaration on the Rights of Aboriginal Peoples in 2007, and in Canada, in Section 35 of the Constitution Act of 1982, the Aboriginal rights, of which I will not speak, were enshrined. Now, just before I examine this, let's just to sum up what I said about this history, that's that prior to 1982, the imperialist policies of Canada had severely shaken the foundations of traditional Indigenous legal orders by outlawing their actors, by outlawing their processes. I didn't go into the detail, but the Indian Act, for instance, prohibited potlatches, sun dances, required of Indians who wanted to go out from the reserve a permit to do so. So they were very constrained. They were liable to go to jail if they hired a lawyer to argue for a land case. And so these Indigenous legal orders were very badly shaken, replaced by state-imposed band customs and councils, creations of the state to which power was delegated. And so the original Indigenous legal orders had to live in a dangerous situation in the shadow of the state. There was and still is little recognition of Indigenous customary laws in Canada. And as we will see, the constitutionalization of Aboriginal rights in 1982 has not been synonymous with a recognition of living Indigenous law, or even, as in South Africa, of official customary law. And it's certainly not a recognition of the autonomy of traditional institutions, as we've seen in the United States. Canada's recognition of Aboriginal rights is neither a normative nor an institutional form of recognition. This is section 35. The first paragraph is the most important one. The existing Aboriginal and treaty rights of the Aboriginal peoples in Canada are hereby recognized and affirmed. They're not created. They're recognized and affirmed. But no one had defined what these words meant prior to 1982. In this act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis people of Canada. I won't go into this. It's very complicated. You can ask me questions if you want later. 3, well, I won't talk about this, but for greater certainty, treaty rights includes rights that now exist by way of land claims agreements or may be so acquired. We can talk about this later, but in Canada, modern treaties, modern agreements are signed with Indigenous communities. And finally, notwithstanding other provision, the Aboriginal and treaty rights referred to in section 1 are guaranteed equally to male and female persons. Indigenous women strongly demanded, this was not initially, it was introduced in 1982. They had to modify the Constitution to satisfy the demands of women who were afraid that under the guise of Aboriginal rights, more traditional patterns would be introduced detrimental to their equality. So just some statistics. Aboriginal peoples in Canada comprise less than 4.3% of Canada's total population. Geographical distribution. Out of 10 Indigenous persons live in the provinces and territories west of Quebec and in the north of the state. This means that west, this means here and in the north, because the northerner you go, the more Indigenous the environment becomes. There's a lot of intermarriages. 1 out of 2 Indigenous person unites his life with, or her life with, a non-Indigenous person. And urbanization. There's a great level of urbanization, also Indigenous peoples in Canada. Now, just to give you an idea of the size of these reserves in Canada as opposed to the reserves in the United States. These are tiny specks. You must realize that some of these reserves were traded for traditional territory the size of France. Just to give you an idea, just in my province, France can be stuck in 5 times. So Canada is a huge country. This is very, very powerful image. 99% of the Canadian population lives in the blue area. The small dots are the First Nations reserves. And so the farther north you go, the more Indigenous peoples you meet in greater number. And it's in the far north that the extractive industries are doing their work. What kind of protection does Section 35 provide? Well, it's not an institutional recognition. Aboriginal peoples are not recognized as domestic dependent nations, invested with limited sovereignty. It's not a normative recognition. Canadian courts are not called upon to apply customary law subject to the Constitution. What it provides are judicially defined Aboriginal rights, but they're rather interests or practices, as we will see. What Section 2 has been interpreted by the Supreme Court as providing are collective territorial and cultural rights that provide a shield against unjustified executive and legislative action by the federal and the provincial territorial government. As you will see, I'll give you an example immediately so you understand what I mean. If you succeed in establishing an Aboriginal right to hunt, you're caught hunting without a permit. You go to court and you claim an Aboriginal right to hunt in that area. We'll see what kind of proof you have to do that. But if you succeed in proving this Aboriginal right to hunt, your right is elevated to the status of a constitutional norm. It's as if you're bringing a shield in court. And this shield will protect you against the application of any legislation, whether federal or provincial, that infringes that right. If your right is limited, by the legislation will be held unconstitutional unless it satisfied a justificatory test. So the court not only has elaborated what Aboriginal rights are, it has also elaborated a test to justify the limitation of those rights. I don't have time to explain the test. If you want, during the discussion, I'll go through that. Aboriginal rights entitles in Canada. If Aboriginal rights in Canada are not based on a remnant of pre-Columbian sovereignty, on what is it based on? The Supreme Court said literally, Indigenous peoples have rights because they were there before us. So it's the prior occupation of the continent that justifies the recognition of rights, and the Aboriginal cultural distinctiveness test. It's the specificity of their culture that justifies their recognition. So the court recognized two subcategories of Aboriginal rights. Aboriginal rights per se, which guarantee the right of an Aboriginal community to practice pre-Columbian cultural activities, and Aboriginal title, which guarantees the right to exclusive use and occupation of the territory itself. The first one is much more generous, but only one group succeeded in establishing the existence of an Aboriginal title since 1982, and it cost them $45 million to lead their case up to the Supreme Court. So these rights are based on a cultural distinctiveness criterion rather than a recognition of the survival of a limited form of Aboriginal sovereignty. Now, this is the definition given by the Supreme Court of Canada to an Aboriginal right. An Aboriginal right is an element of a practice, custom, or tradition integral to an Aboriginal society's pre-contact distinctive culture. That is, the practice must have been an integral element of the way of life of that society prior to contact with the Europeans. And as you understand, this approach encourages the essentialization of Aboriginal identity, because you must go to court, and the only Aboriginal rights you can prove are activities that were culturally fundamental before contact with Europeans. So, guess what? The rights that have been recognized are Hollywood-type Indian stuff. Hunting, fishing, but bands that have tried to adopt a labor code, for instance, and enact it, were said in court when the labor code was challenged, well, how can you justify a labor code? What kind of traditional pre-Columbian activity can you invoke to justify this? They tried, some other tribes went to court claiming a right to self-government. They said, gee whiz, we were self-governing in pre-Columbian times. And the court said, no, that's too general. You have to claim a more specific right. In the case I just mentioned, where they claimed a general right to self-regulation, the poor Indigenous peoples were really strategically maladroit, to say the word, because they went to the Supreme Court claiming that this right to self-government allowed them to have casinos. That's the worst case scenario. I mean, they literally shot an arrow, if I may say, in their foot. And so what the court said is, no, this is too general. What you're asking is, you're claiming an Aboriginal right to hold high-stake gambling. So imagine the pressure, the proof they had to make. They had to prove that prior to contact, they had high-stake gambling. So naturally, they lost in atomic fashion, so to speak. And but all this to say, I'm very harsh on the court, but I do not deny that a lot of Indigenous peoples succeeded in establishing rights to hunt, to fish, and that created also a political momentum it made people realize that some rights exist for Indigenous peoples. And I'm not saying that the advent of this Aboriginal rights doctrine did not entail a lot of political consequences that were good for Indigenous peoples. The other thing that was recognized by the court in a case rendered 11 months after the first one, which defined Aboriginal rights, was the Aboriginal title. An Aboriginal title confers a more generous right, as you'll see, because whereas Aboriginal rights are concerned with pre-contact activities and practices that have to be proven one by one, by the way, Aboriginal title confers a right to the territory. That is the right to exclusive use and occupation of the land held pursuant to that title for a variety of purposes, traditional as well as modern. So, whoa, that sounds interesting. It means that if you can prove your right, and we'll see it's very difficult, but if you can prove that you have an Aboriginal title, then you're allowed to do anything you want. A ski resort, hydroelectric dam, petrol, what you want. So this seems to take us out of the cultural essentialization. Whoa, listen. Supreme Court is too devious for that. So the court created, out of nowhere, took this rabbit out of its judicial hat and included this inherent limitation. It said, the uses made of the territory are subject to the inherent limitation that they must not be irreconcilable with the nature of the attachment to the land, which forms the basis of the particular group's Aboriginal title. So the court said, for instance, if you establish an Aboriginal title because that territory was a hunting territory, you cannot allow an open pit mining to be performed. So again, the court brings back this capacity for non-Indigenous judges to determine what is the essence of Aboriginal culture. The proof in both cases is very hard to make. Aboriginal rights, as we've said, necessarily depend on facts and events that occurred hundreds of years ago. And they involve claimants whose traditional culture was non-literate. So if you want to prove a pre-Columbian activity, you bring in courts, archaeologists that are going to find arrowheads in the ground to prove that you were there, that you were hunting. You will need anthropologists, you will need historians, and you will need archaeobotanists, ethnolinguists. All the ists you want are in court. And it's a battle of social science. And we can discuss this because it politicized the whole field of social sciences in Canada where Indigenous peoples are concerned. Proving an Aboriginal title is especially difficult because it requires the Aboriginal crew to establish that the land was occupied by the Aboriginal claimants prior to the assertion of Canadian sovereignty. It's complicated. Why isn't it, in this case, contact? Why is it sovereignty? It's because the Aboriginal title is defined as a right, a real estate right that burdens the Crown title. And the Crown cannot be the proprietor unless, before it asserts Canadian sovereignty. But still, this means that the assertion of sovereignty dates back to about 150 years old. So it's foreign, but that's not the complicated issue. The complicated issue is the next criteria. At sovereignty, that occupation must have been exclusive. Now, most Indigenous peoples in Canada are either nomadic or semi-nomadic. Try for them. They don't have a library they can go to and pick a book made out of, leaves and tell you, yeah, we were there. They have to prove this with their oral tradition. They have to prove this through the use of social science evidence. So basically, as I said, Aboriginal treaty rights are collective, territorial, and cultural rights. They are not recognition of legal orders. They operate as a shield. to protect certain activities and certain interests in Aboriginal title against the implementation of provincial or federal legislation. Why did we not follow the American path? Why didn't the court in 1996 just say, well, you know, they, like in the United States, they're dependent domestic nations? Because it made no sense in view of the socio-demographics of Canada in 1996, which had nothing to do with the American socio-demographics of the 1830s. There's also the fact that more than 600 Aboriginal communities in Canada, few of which are large enough to be bearer of a self-government right. That's another issue. Who's going to exercise that remnant of sovereignty? And finally, the court lacks the legitimacy to recognize a generic right to self-government and prefers to encourage the signature of these modern treaties I mentioned earlier. Why not follow the South African path? It's colleagues are now in the process of revitalizing these legal orders. And finally, interests. So, thank you very much for listening.